Okay, so moving on. This is part 3. This is Ann Taylor's rebuttal to Jeff Nye's rebuttal regarding the defense's motion to suppress the IGG information.
I'll start backwards. I will answer the court's question that the court posed to Mr. Nye. The state is burdened by what the FBI did here. Every action the FBI took in here, all of the secret actions that they took, show you that there is an expectation of privacy that society is willing to accept. They didn't want anybody to know what they're doing. It is interesting to hear that discovery requests and motions to compel and orders have been complied with when I've learned at least 3 new things in the course of preparing for this hearing and being at this hearing so far today. That's a surprise to me.
Well, it does appear she did get some more of the discovery then during that closed hearing, or things that were given to her right before that. Now, I did just see today, as I'm recording these recaps, that Judge Hippler decided that he will release the transcript of the closed portion of this hearing. So the defense and the prosecution will have a chance to redact anything they need redacted, and then it will be released. So we will finally get to see these things that she's talking about that she just learned that morning. And also whatever she was discussing medical-wise as well. But let's continue.
So I wanted to say that, and I want to go back to the trash pool. And I want you to know, when you consider this, that that particular area had an ordinance that trash had...
Supreme Court reject that argument very recently.
Your Honor, they might have, but that ordinance isn't all. I was starting with the ordinance, that it has to be collected by a trash collector, that a certain trash collector, and that you have to put your trash out too. In that circumstance, the FBI worked with the trash collector and had them go just to get that trash and then take that trash somewhere else too. And those are some extra actions that the FBI took in this particular case that changed them.
How does that change the analysis?
Well, Your Honor, I think that it changes
the expectation of privacy is lost when you put it in the trash can to be taken away, per the Supreme Court's opinion, even if it's a well-regulated neighborhood by ordinance that says when and where you have to put your trash.
And I was hoping Hippler would bring that up, because I've seen a lot of people trying to say because it was in a gated development with an HOA that you need a warrant. But Supreme Court has ruled that it doesn't, even in those types of situations. So I'm glad Hippler brought that up.
Well, Your Honor, I think that there is an expectation of privacy when you have to comply, you have to put your trash out in that particular manner.
Okay, this is new to me, and I don't live in a gated community, but I live in the county, and the garbage disposal company says that you must put your trash out in this particular receptacle, and you must put it out here, out by the road, at a specific date. So if that's the case, wouldn't everybody be able to say, well, no, that Supreme Court ruling's wrong and I have an expectation of privacy? Like, her argument makes absolutely no sense to me.
Not the case.
Unless
you're saying the Supreme Court was wrong, the Idaho Supreme Court was wrong, and you're reserving that for a later higher appellate court, that's fine.
Your Honor, I may not always agree with the Idaho Supreme Court on everything.
But I have to follow what they say.
But I have to make a record when I don't agree.
I appreciate that. I'm just trying to make sure we're talking about the same thing here.
And I have to distinguish the case as best I can as well. And I think it is different when you have the FBI telling the trash man what to do.
So there we go. Just like with the IGG, she doesn't agree with precedent, with set law, so she's wanting to change it. So a lot of what she's doing is to get through the appeals court up to the state high court and then eventually the federal high court.
I'll move on to something else. I want to talk about now where Mr. Nye started that Department of Justice interim policy, and he read you the first footnote, and I would just direct the court to pages 6 and 7 in that, and that is that the FBI is not to search databases that they're not allowed to, in this case, the two of the four that they did. And the next page talks about the things that have to be kept in case there's a prosecution case. The prosecutor talked to you about, well, this is a tip. This is just a tip. It's like an informant. And it's thought of in this Department of Justice policy as more if they're told to keep things in case there's a prosecution case. And so that should be considered when you're considering the entire picture that we have here in light of the amount of secrecy that happened here. That takes it out of being a tip. It takes it out of being a lead in the case.
I'm not exactly sure how that would take it out of being a tip or a lead in the case, just because they didn't save the paperwork. If DOJ policy said they should save it, but if they don't, we know that it's not a violation of the law, because we know that policy doesn't equal law. Does it look shady? Sure. But does it have legal ramifications? No. So I'm not sure why she's now saying that this would go beyond being a tip because of that. But let's continue and see if she clarifies it better.
I would remind the court, I'm sure the court knows pretty well when we're talking about confidential informants and that type of law, you have to have some reliability. And there should be a big question here about how reliable this is, how reliable whatever it was the FBI did to develop this profile with the rest of the secret things that they did in this case and their willingness to violate their own policy. I'm certainly not suggesting that this court create a new Fourth Amendment right based on violation of Department of Justice policy, but I'm saying you should look at that and consider that when you're thinking about what the FBI did here and how credible this informant was, how credible this lead was in this particular case. That's fair for you to consider, just like you would in any other confidential informant type of case.
Okay, gotcha. She's going after it like it's a confidential informant, and we've heard that before, that they consider the IGG, the genealogy, a confidential informant. So she's trying to say that because they aren't reliable, because they went outside DOJ policy and they didn't keep all their materials and they've kind of kept everybody in the dark, that it should be equal to an unreliable confidential informant. And I could see that. That is a good point she makes, and the judge is going to have to look into that and say, well, since this was being used as a tip, is it the same as a confidential informant that goes to law enforcement and says, hey, yeah, I've got this information on this person? So he will have to weigh that reliability. But again, it's not illegal for the FBI to go outside their policies. So again, does it make the informant, in air quotes, unreliable? And just because she couldn't see the work they did on the IGG, does it really make that unreliable, especially when in the end that tip led to an STR direct match? That there was no doubt it was Koberger's blood, or I mean not blood, but DNA on that knife sheath. At the end of the day, it's still a direct match. That even if the tip helped them get there, it's still a direct match. So the informant was apparently credible. And she did say no, she's not suggesting that they create a new Fourth Amendment, right? But I still feel like that's what she's getting at. Like, her and Logston, to me, have so much bigger plans for this case than just their client, than just trying to get Koberger off. They want this to be a landmark case about IGG. You can just tell. They're chomping at the bit for that. But let's continue.
I would like to distinguish what we have here with our subsequent search. I talked a lot about that before. I won't go too far on that. This is a second search and a third search if we're just focusing on the two SNP files. These are extra searches that happen after the initial search is done and the STR profile is developed and it goes into the CODIS database. This is completely different and a SNP is different. You heard a lot of testimony about how this is sort of new and evolving technology and the standards that apply are catching up and there's best practices. You heard a lot about that today. So I don't think we can just say, well, if CODIS is fine, this is fine. It's not the same at all. There is a ton of information. It's your whole genome that gets profiled. Maybe the SNP that uploads into MyHeritage, which it shouldn't have, maybe that SNP doesn't tell you certain things about a health profile, but the potentiality is there in the SNP profile. For $12, you can upload that profile and find out all kinds of personal health information. It's the potentiality of that. And that's the Carpenter case that talked about the potentiality of that. People have an absolute privacy interest in their health matters. Idaho has a couple of different laws on the books. It has the family DNA law on the books. And think about HIPAA. I mean, we all have to sign those forms every time we go to the doctor if we want anything released to our surgeon. Health matters are important.
Okay, but she's losing me with that argument, and I can't tell she's losing Hippler on that either, but they weren't looking up his health information. They were just looking to see if they could find a distant relative to determine a path forward for finding the perpetrator that left their DNA on the knife sheath. That's what they were doing. They were looking for names of relatives that they could then go off of and say, yes, you were headed in the right direction. They weren't, at least not that any of us are aware of. Maybe that was discussed in that morning thing that they did delve into his medical history, but if it's just being used for identification, her argument to me is going nowhere. To compare this to HIPAA, if you're using the DNA for some sort of medical reason, sure, that's a whole new argument, but you're using it to identify a criminal by finding names of people in a family tree so that you can then go interview them and say, hey, do you have a relative that lived out in this area? I mean, that has nothing to do with medical information. I feel like she's just trying to muddy the waters here. And I understand that's her job. Her job is to throw spaghetti at the wall and see what sticks. I mean, you would be ineffective counsel if you were not pulling out all the stops and doing everything you could for your client. But I feel like some of these arguments need to be based in the facts of the case, the reality of the case. And the IgG was being used by the FBI to find the perpetrator, not to dig into somebody's medical history. So to me, she's just gone way, way far off base with this argument. But like I say, we shall see what Hippler decides on it.
If you can upload one of these profiles for $12 and find out all kinds of information, how is that not a Fourth Amendment issue? That's what that SNP profile can do, and that was done twice without a warrant in this case, and there should have been a warrant. It violates Fourth Amendment rights, Article 1, Section 17 rights, and this must be suppressed.
Okay, so that was Anne's rebuttal to Jeff Nye's rebuttal, and it is going to be interesting to find out what Judge Hippler rules on this. My personal opinion is, he said before, he has to go with what the state courts have ruled, what the laws are of the state. I don't feel he's going to toss the IgG. I just think that he's not the type that's going to try to set some new precedent out of his courtroom. And then Anne is going to be free to appeal that as far as she wants, as far as the courts will let her. But I don't see him tossing the IgG, and then I think it ends up not rearing its head again in this case until appellate later, like if Koberger's found guilty, then in the appellate courts after that, because the prosecution has already said they're not using the IGG information at trial. So this would be the last I would imagine it would be seen, unless Anne tries to drag it up again during the defense. But then in that case, the prosecution could always do a motion in limine to try to get the defense stopped from even bringing it up, which would make it a moot point. So lots of things for Judge Hippler to consider, and this ends the segments that are on the IGG motion to suppress. The next segments I will be doing will be the rest of the hearing on January 23rd, which are the Franks motion information. And that's a lot longer one to to go through and dissect. So I'm not going to work on that one tonight. That'll be coming in the next couple days. I'll also want to thank everybody for hanging in here and listening to these. And if you have any questions, let me know in the comments. Thanks.